The case that came up before the Supreme Court comes on appeal from the Fifth Circuit. Consumers Research petitioned for review in the Fifth Circuit, contending that the Universal Service Contribution Scheme violates the non-delegation doctrine. The en banc court granted the petition, replacing a panel decision to the contrary. Once again, we have a case based not in a violation of the law, but of court precedent. Consumers Research did not claim that this scam violated the law, but the court's non-delegation doctrine. In the federal government of the United States, the non-delegation doctrine is the theory that the Congress of the United States, being vested with all legislative powers by Article 1, Section 1 of the United States Constitution, cannot delegate that power to anyone else. However, the Supreme Court ruled in J.W. Hampton, Jr. and Company v. United States for 1928 that congressional delegation of legislative authority is an implied power of Congress that is constitutional so long as Congress provides an intelligible principle to guide the executive branch. The problem is that the Constitution doesn't deal with implied powers, but with vested powers, as the necessary and proper clause states. Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Since the Constitution vests Congress with the power to lay and collect taxes, this delegation of the power seems to violate the necessary and proper clause. In the full Fifth Circuit's view, the combination of Congress's delegation to the FCC and FCC's subdelegation to the administrator violated the Constitution, even if neither delegation did so independently. So if the Fifth Circuit found the scheme violated the Constitution, what was it based on? Article 1 of the Constitution provides that all legislative powers herein granted shall be vested in a Congress of the United States, Section 1. Accompanying that assignment of power to Congress is a bar on its further delegation. Now, at the same time, this Congress has recognized that Congress may seek assistance from its coordinate branches and vest discretion in executive agencies to implement the law it has enacted. Now, to some extent, this position is correct. Congress lays the taxes, but the IRS handles the collection. However, there is nothing in the Constitution that allows Congress to delegate lawmaking power to the executive branch, much less those powers be eventually delegated to a private company.